welcome everyone who has joined us today, wherever you are in the world, or Auckland, or the rest of the country, and whatever lockdown level you're in. We hope you are staying safe, and we hope that also you have been able to cope with being put back into lockdown again. For many of us, it was, if not a surprise, then it was a bit of a shock, and it's certainly something that none of us were looking forward to. For those of us in Auckland, we have another couple of weeks to go at level 4 at least. You're very welcome to joining us today at this KTC seminar, where we will be looking at some issues related to COVID-19. And I'd like to introduce Laura Chapman. By the way, I'm Scott Worthy, and I'll introduce Laura Chapman, another partner at KTC, who will take us through what we're going to cover today.
Thanks, Scott. Hi, everyone. So you'll see from the slides you've got in front of you now, we're going to cover 4 broad topics. Unfortunately, we won't have all the answers for you because some of those are all developing, but we'll do our best to kind of raise the issues and give you a good steer on what we think at this stage these answers might be. Happily, we'll start with the first one, which does have some answers for you in terms of what government assistance is available for businesses at the moment, and what we're looking at, because obviously, as we know, this changes as this pandemic progresses. The second is looking at working in the COVID environment, and as I'm sure all of you experienced this time around, it's not a carbon copy of the long lockdown we had last year. There are quite a few differences and quite a few different things that we need to think through this time around. Having said that, it's not our first rodeo, as we say, so there are some things that are familiar as well. So we'll go through some of those issues. Scott's then going to provide us with a case law update. So what has happened in the last while around decisions that have actually been made that can help us with some guidance as to what we do when there are lockdowns and disruptions in our business as a result of COVID. And the last thing we'll talk to is some of the challenges we're seeing in relation to vaccinations and how they're affecting some of our clients and businesses. So with that, I will hand back to Scott to start us off with looking at the government assistance that's required.
Thanks, Laura. As Laura said, this is one area of the presentation where there are some answers, but it's useful to gather together all of the suite of measures the government has put in place in terms of business. There are some changes from last time, but some of the topics will be familiar from the last lockdown. So the number one issue is the wage subsidy. As you'll see from the slide, the wage subsidy is made by the employer with an obligation to pass on the wage subsidy to employees. The figures have gone up. It's now $600 a week for full-time employees, $359 for part-time employees. The other thing that's slightly changed from last time is that the government has been now 2 distinct periods. So the first period is the period 17 to 30 August. And during that period, there must be a 40% decline in revenue to qualify for the test, to qualify for the wage fee. Now that, of course, can be predicted revenue or actual revenue. Those applications for that round close today. So if you haven't applied for the period 17 to 30 August, you need to do so as soon as you can and before midnight. A new round will then open for the period 31 August to 13 September. And again, for that 2-week period, you need to show a 40% decline compared to average income or average revenue. The next slide shows the obligations that employers have to comply with to obtain the subsidy. Most of these will be familiar from last time. Number one, of course, the point of the subsidy is that employers retain people in employment and retain that employment connection rather than potentially making people redundant. So the employees have to be retained for the period of the subsidy. Secondly, and this is an important theme that will run through all of today's presentation, employment law continues to apply. The government has not exempted anyone from any employment obligations in New Zealand. The government continues to believe that this can be managed within the employment law framework we have already. So that includes things like the Employment Relations Act and the Duty of Good Faith, the Minimum Wage Act, the Holidays Act, and of course the Health and Safety at Work Act. So all those guidelines continue to apply. And it's important to note that when you apply for the wage subsidy, you have to declare that you will continue to abide by all those obligations. The employer has to use best endeavours to pay at least 80% of the employee's ordinary wages or salary. That is not a license to simply reduce everyone's salary or wages to 80%. The government is again very clear in the declaration form that you have to sign that employee wages, salary, hours cannot be changed without their written consent. But the obligation is to try and pay at least 80%. An employee will not be compelled to use their leave entitlement unlawfully. Having said that, there are lawful ways to make an employee take annual leave. After you try to agree with an employee about the leave, and then give 14 days. The last point there, as I mentioned, out written consent. And so those declarations are very important, and the obligation potentially is to repay the wage subsidy if those, there is, that's number one on the suite of measures the government's put in place. The second is the Resurgence support payment. And this is a separate payment to the subsidy with separate rules, and businesses can get both at the same time. This is available now, and the government has activated the Resurgence support payment, and you can apply through IRD. This is for businesses that experience a 30% revenue drop due to an alert level change over a 7-day period. So 7 days, not 14, a 30% revenue drop because of an alert level change. This is a lump sum payment, which is the lesser of $1,500 plus $400 per full-time employee. Fine. Now, the government says this support payment is designed to help employers with fixed costs like rent that need to continue to be paid during this period. And the business, of course, takes that money and uses it to keep operating rather than necessarily passing it on to employees. As I said, you can get both payments, the wage subsidy and the Resurgence support payment. And there are a couple more payments which are designed to help employees who have been affected by COVID. The first is the short-term absence payment, and it's available for employees who are waiting the result of a COVID test, but who can't work from home. So it may be that the employee is sick and unwell and is getting sick leave, and the employer can use this money to help pay for that. Or it may be the employee feels well, but has been told to self-isolate while waiting for a COVID test result. The short-term absence payment, it's a one-off payment of $359 for each eligible worker. Now, there's a slightly different payment called the Leave Support Scheme, and this is available when an employee needs to self-isolate and cannot work from home. So this is a situation where the employee might be sick from COVID and is self-isolating in a jet park, or an employee has been told to self-isolate because they're close contact. And Laura will talk a little bit about the effect of employees self-isolating, and we've seen that already with countdowns being closed, for example. If employees are self-isolating, the employer can get this assistance to help with that. It's paid as a lump sum, $600 a week for full-time workers over 2 weeks, so a total payment of $1,200. Again, it's designed to be passed on to the worker to help them when they're self-isolating. If they're sick, for instance, again, the employer can use it to help pay for sick leave that they would otherwise be getting. The last point there, it includes parents or caregivers of someone who has been told to self-isolate at home, and the caregiver needs to stay home to look after that person. So a variety of schemes and approaches there. All of them have different rules. All of them have little quirks that you need to comply with. But there is, fortunately this time, pretty good guidance on government websites about how to access these schemes and how to use them. So turning from government assistance, our next topic, which Laura will take you through, is working in the COVID environment.
Thanks, Scott. When we talk about working in the COVID environment, it's obviously a really, really broad topic, and it's one that we could probably talk about and complain to each other about certain aspects of for a long period of time. But what we've tried to focus on really is looking at what the issues are that we're experiencing and seeing coming out of lockdowns, and the likelihood that we may have more of them in the future. So if we look at dealing with alert levels 3 and 4 on our next slide. So the first thing, and we've seen this quite acutely in the latest version of lockdown, is be prepared for short notice lockdowns. I think a lot of employers will have done this anyway, but it's things like making sure you have policies around what you do with your laptops if you can work from home, making sure your employees actually know what to do in a lockdown the next day, having good communication systems, making sure you have up-to-date contact details for everybody so that you can get hold of them at short notice to essentially say either do or don't come to work tomorrow, and work out what is going to be happening the next day if you're told suddenly that you're going into a level 3 or level 4 lockdown in particular. In terms of the alert level requirements, one of the things I want to pick up on this again is that this is not a carbon copy of last time. When we had lockdown version 1 back last March, we had this concept of essential businesses and who was an essential business, and from that came discussions around essential workers and who were essential workers. And that's not the case this time. So the government narrative and the stay-at-home order that's come out now talks much more about an alert level 4 business or service. And so the categorization of who is actually able to continue to operate has changed. And there's not a huge level of kind of deep guidance into what that means, except for certain sectors. So I know for the construction sector, for example, there's quite detailed guidance on who can be working and who can't. But I think this is a very real issue for a lot of businesses where they may have essential functions, but not all employees work within those functions, and not all employees can work from home, even if they don't work in those essential functions. So actually sorting out who should be working and who shouldn't be working during an alert level 4 lockdown is particularly difficult. And I know we've seen some media around that lately too. And so I think it's also having a good overview of your business and an assessment of who actually is working in the part of your business or the function of your business that is an alert level 4 business. And then looking at also some of the requirements. So essentially at the moment under the latest order, there's a stay-at-home order in relation to everyone obviously staying in their houses except for certain reasons, and that is personal essential travel. Now, one of the reasons you can leave your house for personal essential travel is to go to work at an alert level 4 business. but that doesn't really help us in any great detail as to what, again, that actually means. So spending some time thinking about that is going to be really important, both for this lockdown, obviously, but also in the future as well. We also have the issue more and more coming up that you may have workplaces all over New Zealand, for example, and they will be operating at different alert levels. So you will have different requirements at different alert levels. So you may also have employees actually going across what we're now calling borders. So Auckland has now has a border established, and to get across that border you need certain documents and requirements, and one of those might be a letter from your employer that explains why you are able to travel in order to support an alert level 4 business, which is formerly what we thought of as being essential businesses. And I know that a lot of consideration will have to be given to how that is communicated, and both to your employees, but also to authorities. So what does the Ministry of Health know about what business you are operating and whether your employees will be crossing borders? And what will those border officials know about your employees, and what will they need to have on them? So as well as a letter, they might have to have some identification or otherwise if they're crossing these borders that have been put in place. Also, if like me, you have to look at your own personal obligations at each of the levels. So every time you go into it, reminding yourself, I've heard a good phrase about level 3 is like level 4 with takeaways. But there are actually other, when you start to read the fine print, there are other requirements we do need to think about in terms of social distancing, PPE, what is required when people are actually working in alert levels 3 and 4, and particularly in the alert level 4 businesses. So worth just looking those up again. I won't go through them all, as I say, we've got limited time and a lot of topics that I'm sure you want to hear about. But the other thing is we're seeing, particularly this time around, and Delta is a bit of a game changer in terms of this, but managing the risks associated with unavailable workforces. So I don't know how many of you have scrolled through the places of interest now, but it is a very, very long list. And everyone in those places of interest are being asked to isolate for a period of 14 days, which is quite a long period of time, and test through various cycles within those 14 days. And you can imagine that for a lot of businesses, and some of you may have experienced this, if all of your workforce that was there on a particular day now has to self-isolate for a period of time, and particularly if they can't work from home, that creates real difficulties. So what will you do if your business becomes a place of interest, to the extent you have public or contractors or anyone else who are there, and it means a chunk of your workforce is taken out? And again, that might come back to some of the patterns that we've seen, some people operating where they have teams. So particular teams in a workplace on one day and another team on a different day, so that essentially you can continue to operate if there is a particular time when someone who is infected with the Delta variant or COVID generally attends the workplace. There is, as always, lots of issues around leave entitlements and requirements, and that comes up in pretty much every lockdown. As you know, the general position in relation to holidays is that holiday leave or annual leave has to be agreed as between employers and employees, or you have to try and reach agreement. If you can't reach agreement, then you can direct someone to take leave on 14 days notice. That doesn't help us when we're in these very short notice lockdowns, because that 14-day period is fairly crucial for some businesses. And I've seen a question which we'll talk to a bit later on the Q&A about essentially the tax treatment in relation to some of these leave liabilities. And I think there are a lot of different issues associated with leave that we see, because there are also contractual requirements that you might have in relation to leave that will come up during these periods of lockdown, and it's not always possible to reach agreement with your staff on what that will look like, I should say. The last and probably the most controversial issue is pay. So what do we pay our employees during a lockdown? And the starting point for this comes back to something Scott mentioned at the outset of the declaration for getting the wage subsidy, is employment law continues throughout any of these lockdowns. So these lockdowns don't change the normal laws that we have in place. that is an across the board issue, even if you're not giving a declaration for the wage subsidy. So overall, we do have to come back to our usual principles. Now, Scott's going to go through shortly some of the case law that has come out of the lockdowns last year and what the authority thinks of some of these issues. But the same issue remains that there's questions over different categories of workers during a lockdown. Now, if there is work and people are going to do it, so you are an alert level 4 business and there is people working, obviously they get paid as they normally would. If you're an alert level 4 business and someone can't work because they have, for example, childcare commitments or they might be a vulnerable person, then there are questions over whether or not you continue to pay them, or whether in fact they take a period of leave during that time so they have work available. There is then questions about people who, for example, you're not an alert level 4 business, but the person cannot work from home. So in those circumstances, there's a question, and this comes up, and you will have heard it a lot, is this ready, willing, and able question. The courts haven't helped us very far in relation to this issue so far. There is some risk there for employers if they decide not to pay. There are equally some arguments around not paying. And I appreciate that's a very woolly answer, but unfortunately with all these things, it comes down to specific circumstances of the employer and the employee at the time. So they're quite a fact dependent calculation, and Scott will be talking a little bit more about these when he goes through the case law. So if we go to our next slide, what we wanted to talk about was a little bit more of the wider picture of working in a COVID environment and some of the other considerations we need to take around the ongoing issues we're seeing. The first one, and I'm sure people will have heard this, but worth just mentioning again, was looking at information security and privacy. So, you know, we all have technical issues. We've experienced them on this call as well. But the issues that sometimes come up mean that there can be concerns around privacy that are shared, or issues around personal data that's shared either inadvertently or deliberately in some cases, because where we've seen issues is things like personal internet connections are not as secure as your work information technology systems. So for example, if you're not operating via a VPN, there might be some risk to your data that's going across those networks. Also, I've seen examples in the past, and happily not more recently, but in the past, of information being on camera that shouldn't have been. So someone not being aware that someone on the other side can actually zoom in and look at different information via people's cameras when they're on, and have information in the background, either on a second screen or on a piece of paper or something that's in view. So all of those things are just worth thinking about. You've also got people printing things potentially at home where they might not have a shredder. So just again, thinking about where your information is going and how it is protected in that broader sense is quite important for periods of time that you spend in lockdown, and again, for some businesses. Health and safety there is a huge one. We get a lot of questions on workspaces. So we're working for quite long periods of time. I don't know about you, but if you're anything like us, we sit at a desk and a monitor for a long period of time. So one of the things that's important for us is getting up and having breaks and making sure we're sitting properly, etc. All of those things around workstations are quite relevant when you're at home. You have a limited amount of control to be able to actually, you know, you can't, in a lockdown, we can't go and inspect people's places of work or anything along those lines. But what we do need to do is make sure that people are aware of the things they should be thinking about in relation to their home environment, and that perhaps they have thought through some of the issues that they might experience in terms of health and safety if they are spending, again, time at home and working from home environment rather than their usual workplace. I will just skip as a corollary to that to mental health, which is part of the health and safety, but I think one that we wanted to call out specifically. We knew from the last lockdown this was potentially an issue. We know now it is more of an issue, and worth all employers just taking the time to try and check in on people that might be isolated and or working long hours. I know there's issues that some people have with being on endless Zoom calls or endless other calls, and other people actually at the other end of the spectrum who are feeling isolated because they're perhaps not on calls and they're being left off and they're not sure what's going on with work and experiencing anxiety about that. I know there's a lot of employers out there that have some fantastic systems to be able to keep in touch with their employees and checking in, and some that even have wellbeing services that are doing that for them, but definitely a key one to be thinking out about. I think on the back of that too is being able to take a flexible approach. Speaking as someone who has small children, sometimes you need to split your workday slightly so that you might not be working from 8 a.m. to 5 p.m. You may be working from 6 a.m. to 11 a.m. and swapping out with somebody else who needs to do some work, so you can juggle children and everything else that you wouldn't normally need to do when you have your ordinary working environment. And that just means that people who can be more flexible have a bit more leeway to be able to juggle all their competing priorities, because I think people do have a lot of competing priorities in this situation that is, I wouldn't say not normal, it's becoming more normal, but is outside of what we usually experience in our work environment. And the last one was just something Scott and I were actually talking through, and we're saying some of the ways in which we're working are having quite an impact on our long-term business as usual environment. So one of the things that I know we're experiencing in New Zealand is there's a shortage of workers in particular fields. And in the recruitment battleground, some of these issues, so things like taking a flexible approach, adapting to working remotely, having the option to kind of work from home ongoing even after lockdowns, that's becoming really important to candidates. And we're sort of seeing a shift from people and the way that they're looking at options, and also even some of the other ways that people are treated during lockdown and what happens and how employers look at that. So we just thought that was an interesting issue and kind of byproduct. Not a new one, because I think we've seen it before, but again, just worth thinking about in the way that you structure your responses to the way that we're working in a COVID environment. So with that, I will hand over to Scott to talk us through some of the case updates that have been happening since we had our last long lockdown.
Thanks, Laura. We as lawyers all thought that as a result of lockdown number one in March, April last year, there would be a flurry of cases in the courts and all these issues would be litigated, and by now we would have all the answers. And that just hasn't happened. In many cases, and in some ways that's great news, that employers and employees have been able to work out issues and in fact any differences between them without having to go to court. And that's always the preferable option. But it has meant that in terms of clarifying the law in an unprecedented and new environment, we haven't got an awful lot of guidance. We can say three things. Firstly, it's clear that employment law and the obligations of employment law haven't changed. But it's also important to remember that employment law is designed to be somewhat flexible. It's designed to fit the circumstances, and to be fair and reasonable in the circumstances is the key test in employment law. The second is that if you are making changes or making individuals redundant, all the normal rules apply. You need a genuine business reason for that redundancy, and you need a proposal and consultation process. And the third one is there are lots of issues potentially about paying employees, which Laura has alluded to and which we'll talk a bit about as we go through the cases. There are only 3 cases to talk about, which is probably good news for all of you out there. But the first one is a case called Gate Gourmet. This case is about the minimum wage specifically, and it's only really about the Minimum Wage Act. The employees in this case worked at the airport as airport caterers, in essence providing food for flights. Obviously, with the lockdown and the reduction in international travel, there was not as much work as normal supplying airlines with meals for passengers. What happened in that case was the employer went out to the employees and the unions and said, we don't have any work for you. Rather than go through a redundancy process, we'd like you to stay at home and we'll pay you 80% of your normal wage. We'll apply for the wage subsidy as well. Now, the issue in this case is that all the employees were paid at the minimum wage. So Gate Gourmet only paid the employees 80% of the minimum wage. Normally, of course, you have to pay people the minimum wage. It's a minimum, that's what it's about. But the question in this case was whether you had to pay the minimum wage when someone had agreed not to work. And the court said, no, there was no requirement to pay the minimum wage in this case. So the employment court decision, in essence, says the minimum wage is payment for work. If these employees had been working, they would at least must be paid the minimum wage, but they weren't. Instead, the minimum wage wasn't a guaranteed minimum income. Instead, it was payment for work. No work, no payment. Now, that case has been appealed to the Court of Appeal and will get a judgment probably towards the end of this year, if we're lucky. But the current position, the current law is clear. The Minimum Wage Act only applies where the employee is actually working. The next couple of cases address the issue that Laura was talking about, and is really the key issue that we would like the courts to tell us the answer to as much as they possibly can. But it's important to know that these two cases are only in the Employment Relations Authority, so they're not binding case law, and they don't tell us what the law is. But they do examine the issue of people being really willing and able to work. Now, the most recent one is a case called Major Motors Limited. And in this case, Mr. Bates was a car salesman. He was paid in two ways. The first was a minimum wage. So he got the minimum wage for working 37.5 hours a week. But he also got paid, and most of his income came through commissions. The commission system he had was essentially, where you sell a car, you'll get a percentage in relation to selling that car. Obviously, during lockdown, at Alert Level 4 and Alert Level 3, he wasn't able to sell cars. The employer in this case said, we will pay you 80% of the minimum wage, essentially under your contract. But we won't pay you your commission because you're not earning any, because you're not selling any cars. And Mr. Bates was upset about that. He said, well, I should be paid 100% of my normal weekly wage, but also should be receiving some sort of proportion of my normal commission they would earn if I'd been at work. And the Employment Relations Authority said, with respect to commission, there was no entitlement to commission, and the employer didn't have to pass on anything in relation to that commission because that was always reliant on Mr. Bates selling cars. But with respect to his minimum wage, the amount he got every week for just being an employee, the court said, the authority said rather, that he was entitled to 100% of that under his employment agreement. There was no agreement, crucially in this case, to be paid 80%. The employer notified Mr. Bates that he would be paid 80%, but didn't get Mr. Bates' agreement to that. And the authority in this case essentially said Mr. Bates was guaranteed that minimum income under his employment agreement, and it didn't matter that the country was at Alert Level 4 and that he couldn't come to work and that the business couldn't open. It was provided for by the employment contract, and more than that, it couldn't be deducted. So there was no way under the Wages Protection Act that it was lawful to reduce his salary, his wages, from 100% to 80%. And in that decision, the authority again followed an earlier decision of the authority called Raggett and Eastern Base Hospice. In that case, the employees were workers at a hospice shop selling secondhand goods. The employees, of course, couldn't come to work because that shop had to shut at alert level 3 and alert level 4. The employer simply said, well, we'll pay you 80% of your normal wages. And again, the authority said, well, you can't do that. There are a couple of things to remember about those two cases. The first is that they are low-level decisions of the authority, and so that we don't have any authoritative employment court guidance about this issue. The second is that the authority didn't really deal with the issue of ready, willing, and able to work in great detail. So the argument about ready, willing, and able to work is that if the employee is not ready, willing, and able to come to work, there is no obligation to pay the employee. And at least at alert level 4, maybe not at alert level 3, but at least at alert level 4, the employee must stay home and the employer must close its business, unless it's one of those essential businesses. So the argument is, well, in that situation, and it's no one's fault, it's not the employer's fault, it's not the employee's fault. In that situation, the argument is that, in essence, the employment obligation to work and to be paid is suspended for a short period of time. The employee remains an employee, but they don't have to work because they can't work from home, and the employee doesn't have to pay them. Now, that, as I said, only works where the employee can't work from home. As Laura was saying, if the employee can work from home, then you would expect them to keep being paid. And if the employee can come to work because it's an essential business, you would expect them to keep being paid. But where an employee is essentially locked out of the workplace and must stay at home and cannot perform work, there is the argument, still unresolved and still unknown in New Zealand, whether that allows the employer to stop paying because no work is being performed. That is the issue that we're still waiting for the employment court to tell us about. And in the meantime, the most we can say is that stopping payment is taking a risk. We don't know exactly what the courts will say, but we do have two decisions from the authority which rejects that approach. It may be that a different approach is taken when we get to the employment court, but we don't know. So there is a risk in stopping payment even where an employee must stay at home and cannot be working. At level 3, again, there is an even greater risk because employees at level 3 generally can come to work. And so the argument is, in that situation, they are ready, willing, and able to come to work, provided that they can come to a safe, COVID-friendly environment where the COVID rules are being applied. So all of that is a quick march through some case law, but the bottom line of all of that is that employment law rules continue to apply, and the fundamental issue that we'd like some help with about being ready, willing, and able to work is still up in the air. So I'll hand over to Laura, who will discuss some vaccination issues, which is another difficult and developing area of the law.
Yes, thank you, Scott. And speaking of kind of being up in the air, I think it does feel a bit like this is the same territory. We are wandering, particularly as employment lawyers and HR professionals, into territory that not many of us have had to look at before this year. But there is some law on it, and there is a lot of principles behind it that I think are worth going through and having a look at. So If we go to our first slide, I think most of you will be aware there is an order in place, which we've put there, the COVID-19 Public Health Response Vaccinations Order 2021. Initially, that was rolled out in relation to specific MIQ related positions. It was then amended in July this year and now relates essentially to MIQ workers, border workers, across airports and ports, and then air crew members, so people flying on flights internationally, essentially. Those are fairly limited categories. There's been some discussion about whether the government is going to expand that, but so far no news on whether that would or would not be expanded any further by the government themselves. I think what's been interesting and what definitely has changed the landscape a bit is the emergence of Delta, and in particular now this latest outbreak in New Zealand. So if we go on to the next slide, what we are seeing is a lot more employers considering whether or not they should or have a duty to put in place some other requirement for employees to be vaccinated. Now, I won't spend much time on the vaccination order itself, as you'll see, because I think this wider piece is probably relevant to most of you at this point in time, or more relevant to most of you, I should say, to look at if your workers are not covered by the vaccination order, can you put in place some sort of requirement for your employees to be vaccinated? So at a high level, I think our answer to that would be familiar to you, it depends. And that is very, very much down to the circumstances of each case. So what I'm talking about are, again, high level principles. And to the extent I use medical terms, I am not a doctor, but I'm speaking about what I understand from this vaccination, having had to look at a lot of these issues around this more recently. So the first, where we start with the vaccination requirement is a concept you'll all be familiar with, and that is, are we talking about something that is a lawful and reasonable instruction? So what are we actually talking about here? The first part of that, if we break it down, is looking at, is it a lawful instruction for you to require your employees to have a vaccination? Now, there's one argument that says if you're requiring an employee to have a vaccination, that might be a unilateral amendment to their terms of employment, and then on that basis could be unlawful. And that is open to challenge, but it means there are a few ways to look at this then. One is you could look at your current terms and conditions, and if you had a crystal ball a long time ago, and or have added a requirement to have vaccinations if it becomes an issue, then it may be lawful because you may have that, and bearing in mind there are two limbs, so it does not mean you can put it in place, but it might be past that threshold of lawful potentially. Or you might have existing very strict health and safety requirements that could include being interpreted to include a vaccine. Those are fairly, they still carry risk, even if you're trying to interpret a clause essentially that says that you have health and safety requirements, because unless you've given specific consideration to a vaccine, there could be some challenges from employees in relation to that. Another way you could do it is look to introduce, for example, some sort of policy, for lack of a better term, around requiring a vaccination for certain duties. Now, in order to ensure that a policy is lawful, as we know, usually when you are introducing a policy, you would have some form of consultation with your employees in relation to the way in which that policy might look. And there's various things in which you might consult about in relation to that. Another avenue that we've seen is in relation to looking at health and safety requirements. So is the risk of COVID, and in particular possibly the Delta variant, so high that your health and safety laws, the Health and Safety at Work Act, and your obligation to eliminate or minimize so far as is practicable any risks to the health and safety employee? Do you think that's so great that you are required as a result of that act to then introduce, probably again, coming back to a policy, as we talked about, around vaccination? So that's looking at the lawful piece, and layered on top of that, and you will have seen it in the media, is the question over the New Zealand Bill of Rights Act and Section 11, which is a fundamental right which allows you not to be subject to medical treatment without consent, so no mandatory medical treatment. And I've actually even seen references to medical experimentation, which is a different clause under that, from views on vaccinations. But the New Zealand Bill of Rights Act applies only in relation to public organisations and or organisations carrying out public functions. So it is not directly applicable essentially to private employers. So that issue is only relevant, I think, for most private employers insofar as it will help to influence what might be reasonable. So if we're looking at lawful, we say, well, is it part of your contractual terms? For most people, likely not. Is there something that you may be able to introduce a policy or requirement around? Possibly. That's possibly an issue. That is tied up also with potentially health and safety obligations. Now, this is where we get into, is it reasonable? So once you've passed that lawful threshold, is it reasonable in the circumstances? Now, that is going to hang very, very much on your risk assessment. So for all of this, employees' risk assessment is going to be key, and that's not just and that's not usually an HR or a employment law risk assessment, although there's elements in there. It's usually a risk assessment that's carried out by a people safety or some sort of occupational health team that is looking at the actual way in which you operate and what risks that provides you or gives in relation to being exposed to COVID. Now, that's probably what has changed more recently for most employers, is they're looking at the fact that we now have Delta in the community in Auckland currently. And we may have outbreaks in future, and we may have a situation where once we open up borders, we see more and more mini outbreaks here and there, or we may even get to a point where we are living with it. All of that is obviously also under discussion at the moment. Once we get to this health and safety assessment, though, it is looking at, with your different roles, how are they working and what situations are they in that will expose them to risk of contracting and or transmitting COVID to their colleagues. Now, the public health order that I mentioned earlier is pretty much very much on as it sounds like, a public health consideration. When you are thinking about this as an employer, if you're thinking about introducing new policies, you're thinking about it less from a public health perspective and more from a personal and or employee health perspective. And so that's worth thinking about in relation to your risk assessment. Again, like I was talking about with who should be working during level 4, you do need to think about different categories of workers essentially. So what is the work they're actually doing? So for example, I'm sitting at home at the moment during an outbreak. I can do my job well without too many difficulties. I don't have to go out to the public as part of my duties for the most part. So for me, sitting at home is a very good risk mitigation. There are other people who will have to be in the community, they will have to be interacting with people. And if we're taking the example of a health worker, for example, for someone who might be working in an emergency department and dealing with people who are symptomatic, again, that's a different risk assessment for them. And again, it will be a different risk assessment for people who are working at Countdown at the moment, for example. So they are dealing with members of the public in circumstances in which they have had many of their workplaces as places of interest. So the risk assessment will be very, very different depending on who the person is, what functions or tasks they're undertaking, and where that exposes them to risk. And that's where I would suggest employers probably need to do the most amount of work in looking at that overall risk assessment. The other part of reasonableness is thinking about, well, if we get to the fact we think it's lawful because we're going to introduce a policy, we're going to consult on this, we have gone through our analysis as to whether there's Bill of Rights considerations, and I'll get to human rights around this, but we've gone through that assessment. We've done a risk assessment and we think it's reasonable for certain of our workers to have a vaccine, you also need to think about, are there other ways that don't involve a vaccination that would provide you with an effective mitigation tool? So, for example, we've got some things here around wearing masks, physical distancing, remote working is a pretty good one, and or amended duty. So can you change that person's job in a way that means that they won't have so much interaction with people? So we've seen this in a practical example. A lot of supermarkets have the perfect screens now between you and the person serving you. There's a lot of contactless payments. There's different ways, and technology may play a role in this, in which we can shelter people from what might be the worst effects or the most serious risks in relation to that. So again, it's looking at mitigations. So I think as you'll be seeing, there's quite a lot of analysis that employers will have to do if they're coming to think about whether or not they should be requiring employees to have a vaccination. Now, the last tile we've got in there is looking at consequences. So what are the consequences for employees if they choose not to have a vaccination? So let's say you've made it through all of your hurdles and you are satisfied that that it is lawful because you're going to introduce a policy, you will consult on it, you have done a risk assessment that shows, for example, a portion of your workforce is at high risk of contracting and or transmitting COVID to each other or to your customers, and you've thought about whether alternative measures are appropriate. They're not appropriate, so you introduce a policy and then you decide to implement it. Now, when you come to consequences, that is going to be no different to other consultation periods where you're thinking about taking or affecting an employee's employment negatively. So you do need to think about your good faith requirements, and you need to think about what a reasonable, a fair and reasonable employer could do in all of the circumstances. So again, your circumstances will come back to all of the other work you've done to get to the point where you think you can introduce a policy. But it may also come down to the circumstance of the individual employee. And this is where I come to the human rights piece that I conveniently parked earlier. There may be some employees who can't have the vaccine, or some employees who won't have the vaccine for various reasons. Now, and again, I'm not a doctor, but from what I understand of the vaccine, there's very few situations in which someone is not able to have a Pfizer vaccine. And this will depend on the different vaccines, but in particular Pfizer, which is the vaccine that's available. I think it's really only if you are allergic to one of the components of the vaccine. So there's a pretty slim category of people that may not be able to have the vaccine for medical reasons. Now, we know there are other religious and or ethical beliefs out there around vaccination or around medical treatment more broadly. They will not generally prohibit you from having a requirement that certain people must be vaccinated in order to carry out duties. But what it will do is it will create a separate requirement essentially to reasonably accommodate that potential issue if the person that you're speaking to, or if you have an employee that has a characteristic that's protected under the human rights legislation. So the consequences part of it is probably where that's most acute. So what we're looking at, what happens to this person? And so perhaps what we have to go back to is, are there redeployment opportunities available? Are there other things you can do? Likewise, I've heard this from around pregnant employees. We can understand some people might have hesitation about getting the vaccine if they are pregnant. That is not something that is being advised against to the vaccine. So as far as I am aware, in the literature I've seen, is pregnant women are being advised to have the vaccine at this point in time. So there's a question there around what you do. And this is just by way of example, but interestingly, we know that pregnancy is a temporary condition, thankfully. And it could be addressed by way of some form of leave, for example. So we do need to think about consequences, but if you have followed through all these hoops and you get someone who has does not have a characteristic that's protected by human rights legislation, so does not have a disability which results in an inability to do this or otherwise, and has elected not to have a vaccine when you have introduced a requirement, then termination is something that may be able to be justified in the circumstances. But I hope, as you've probably heard from me saying, there are a lot of hoops to get through and hurdles to go over kind of before you get to that stage. Now, one final hurdle in relation to that is there's some commentary at the moment around the category of that termination. So what does that look like? And I know WorkSafe and has put out a statement talking about redundancy in relation to these issues. Now, that has not been tested yet, but looking at this in terms of, is a termination on the basis that you don't have a vaccine that has become a requirement of your position, a redundancy. And as I say, that's not tested, but it doesn't seem to fit the traditional categories of what a redundancy would be. So it's not a something that is surplus to requirements, but it is very much something that you do need to think about for your individual business and look at for your risk profile. So that is a lot of information in a very short period of time around looking at introducing a vaccine requirement for existing employees. If we go to the next slide, we're talking about essentially new employees. Now, the good news is overall, this is slightly easier than introducing a requirement for existing employees. And we have seen a lot of people looking at doing this. There are still some fish hooks. So one is just making sure you are being aware of discrimination and privacy issues, because the human rights protections that I was talking about before, they will apply pre-employment. So if you are excluding people because of a protected characteristic, then you may be attracting liability in relation to that issue. The privacy issue that we've mentioned there is actually in relation to your obligation to only collect information that is necessary about an individual. And if you are asking for vaccine status or you're looking at that requirement, you must be able to justify that again on the basis of why you need those people to be vaccinated or why you need to know they are vaccinated. And that may well be because you have a policy about vaccination and you've been through that process, but you do need to turn your mind to that before putting those requirements into new employment agreements. And the last one we've got there is just in relation to proof. It's difficult for employers to get proof of vaccination of new people unless they consent to it. So again, you can require someone to be vaccinated, but you must also require that they give you satisfactory proof. At the moment, if you get vaccinated, some of you may know you get a card and it's the size of a business card. It would be pretty easy to lose, but there is a way happily that you can apply to the Ministry of Health for confirmation of someone's status if they have agreed that you can do that, or an individual can also apply to the Ministry of Health to get confirmation of their own vaccination status, and there's a form to do that, but it does take some time. So you just need to think about that in terms of your processes. Now, again, I've cantered through what is a lot of information, and I can see we have some questions. So Scott, do you want to have a look at the questions and we'll start to work through some of those?
Yeah, thanks. I see it's gone 5 o'clock, so we'll try to move through the questions quickly. There have been some questions about picking up on the point about asking staff if they have been vaccinated. And one of the issues there is generally that the advice generally is that you need a reason to ask. And that's because the Privacy Act says that you should have a reason, in essence, for collecting information from anyone, including your employees or workers. So generally, you'd need a reason to ask. And if you're in a general office environment working from home, you may struggle to come up with a good reason for asking. Having said that, of course, other businesses will have a strong reason where there potentially is a risk of COVID transmission or COVID infection. So it is something to think about carefully. Guidance also is that if you do ask, employees don't have to tell you the answer, but then the employee can be treated as unvaccinated if they decline to answer, as long as they're aware of the process and aware of that they would be treated as unvaccinated if they choose not to answer. In many cases, though, of course, employees, and we've seen this as well, many employees are keen that everyone else be vaccinated in the workplace, and that many employees are saying, I want to be safe, I want my family to be safe, I want you as an employer to ensure that everyone else is safe and vaccinated at work. So employers are getting pressure both ways, from people who say it's none of your business to people who say we want a safe working environment.
Scott, I've just seen a question as well around is the duty of care for other employees a good reason to ask for the vaccination from employees? It's a good reason, but it's not one that would give you a right to require vaccination in of itself. So you do need to think about that. But as I was saying, with your risk assessment, you do also need to consider what the risk to your employees is in the environment, and also what other factors could be utilised essentially to mitigate the risk to other employees. So it will always be down to a lot of different factors rather than just one reason.
Yes, and we've got a question here about an essential worker who can't work from home. But can't come to work at the moment because they're a sole caregiver and schools are closed. And obviously that's a situation that Laura touched on, and it can occur. If your business is, in a purely contractual sense, if your business is open and you need people to come to work and they choose not to come to work, then in that situation, the normal rule would apply, which is generally that you don't have to pay people who can't come to work because they choose not to. Having said that, you can think about a period of annual leave for that particular employee. That may be the appropriate step in terms of continuing to pay them. It will depend a little bit on the circumstances, but again, it is not the employer's fault that the employee can't come to work, and the employee could expect that person to come to work. So whether there is a legal obligation to keep paying when no work is being performed, probably not. But that's a very limited contractual approach to things, and it may be that you can work through a solution with that employee. It's also important to note that you may or may not have taken the wage subsidy in relation to that employee, and then there'll be obligations under the wage subsidy to pass on that subsidy to that person.
Thanks, Scott. I wonder, I know a few people have asked some more specific questions as well around different issues. I wonder whether we leave it there for this evening, but we will follow up with others who have asked questions on the thread separately. So thank you everyone for bearing with us and attending. I know some of this can be fairly dense to get through, but please stay safe and well out there. And hopefully we will get to see some of you once we're out of lockdown, but we will be in touch otherwise. Thank you, everyone.
Right. Thank you all.